Hi, my name's Ryan Heath, and today we're going to be talking about Estate Planning 101, Basic Documents for Texas Residents. And I'm with Sarah Perna.
All right. So Ryan, can you tell me a little bit about what documents Texas residents need for estate planning?
Sure, Sarah. So every Texas resident should have at least the primary 6 estate planning documents. Those documents include a will, a financial power of attorney, a medical power of attorney, a HIPAA authorization, a directive to physicians, and a declaration of guardian. And so these documents are really helpful in the sense that they allow someone to designate what happens to their property when they pass away. And it also gives them the ability to designate who would make financial and medical decisions for them if the need arises.
Okay, so kicking things off, can you tell me a little bit about what the purpose of a will is?
Sure. So a will serves several key purposes. First, a will designates where your property goes when you die. And so if you don't have a will in place, the state of Texas decides where your property passes, and that may not be to the same people that you would choose in your will. Also, without a will, the cost of going through the court probate process increased dramatically. Secondly, a will chooses who the executor of your estate would be. And the executor is the person that is in charge of carrying out the wishes that you have in your will. And finally, for those people who have minor children, a will can designate who would serve as guardian of the minor children, and the will can also prohibit people from serving as guardian.
Okay, good to know. I think the second document that you mentioned was the financial power of attorney. What about that one?
Yeah, a financial power of attorney chooses someone to step in and take care of financial decisions for you if you're unable to do those financial choices on your own. And so a financial power of attorney is important for everyone. A lot of times I get a question from clients saying, if I have a spouse, do I really need a financial power of attorney? And I always ask them the simple question of what happens if you and your spouse are in a common accident? In that scenario, we need someone named as alternate agent that can step in and take care of finances for you.
Ryan, that sounds like an awfully lot of power to give someone. When does something like that become effective?
Yeah, that's a great point, Sarah. So a financial power of attorney can be made effective immediately, or it can be made effective only upon disability. And so ultimately, when clients are choosing a financial power of attorney, they want to pick someone really trustworthy. I typically recommend that financial powers of attorney be made effective immediately. And the reason for that is that if it's effective only upon disability, then we could have lag time between the actual event of disability and the power of attorney's ability to step in and take care of things.
Okay.
So again, it really comes down to just making sure that you choose a very trustworthy person for that role.
For sure. So then moving on to the medical side of things, what about the medical power of attorney?
Yeah, Sarah. So everyone needs a medical power of attorney. What if there's a car accident? What if someone's in a hospital and unable to communicate with their doctors? The medical power of attorney allows a person to designate an agent to step in and make medical decisions for them if they're unable to communicate with their doctors.
Okay, so then the next medical document would be the HIPAA authorizations. What does that do?
Yeah, so HIPAA laws deal with confidentiality with respect to protected health information. And so what that means is that once you have an adult, that person's medical records, diagnoses, medications, those are all kept private. And so a HIPAA authorization allows you to choose the people that would have access to that information. Now, in the estate planning context, we use the HIPAA authorization because if a client goes into the hospital, we want them to name the individuals that would have access to speaking with the doctors, the nurses, and finding out about what sort of treatments are being provided.
Absolutely. And this sounds like something that I've filled out before at a doctor's office. Is it the same thing?
Yeah. So oftentimes when we go to a doctor's office, the specific provider or hospital group will have a HIPAA authorization form that we fill out. Those forms are typically very narrow and only release information for that specific provider or hospital, where our HIPAA authorization is a broader document that can be used across providers and hospitals.
All right. So the last 2 documents that you recommended were the Declaration of Guardian and the Directive to Physicians. Can you talk a little bit about the Directive to Physicians?
Sure. So a Directive to Physicians deals with certain end-of-life scenarios where there's a terminal illness or an irreversible condition. Some people refer to this document as an advance directive or a living will, and others say that it's the pull the plug or don't pull the plug document. So in fact, the directive is a little bit more nuanced than that. And so specifically what the Directive to Physicians does is it says that if you have a terminal illness or an irreversible condition, do you want to continue receiving life-sustaining treatments or not? And so if you fill out that document, it's very beneficial for your spouse or for your loved ones to be able to make a decision that's aligned with your wishes. But it does override your medical powers of attorney authority to act in that scenario.
And is this going to be the same thing as a do not resuscitate, a DNR?
The DNR is a bit different, Sarah. The DNR is an out-of-hospital DNR. And what that document addresses is if a first responder comes out to your house and you're non-responsive or unable to breathe, will their first responder resuscitate you? And so that's dealing with someone coming out to your residence, where with the directive, we're dealing with a scenario where you're in the hospital, you've been diagnosed with either a terminal illness or an irreversible condition, and then you're making the choice of whether to continue treatments or discontinue treatments.
Gotcha. Okay, so then what about the Declaration of Guardians? What does that one do?
So the Declaration of Guardian is our last core document that everyone should have in Texas. That document really kicks in pretty rare circumstances, but it's still really important. And so as we age, there's a greater chance that we may need someone to take care of us. We may not be able to take care of ourselves anymore. And in very rare circumstances, a court may step in and say that someone needs to be appointed to take care of you. And so in that event, a guardian would be appointed for you. And the Declaration of Guardian allows you to choose who would serve in those roles for physical care and financial control. And so when that document does kick in, then the guardian would assume the roles of the financial and medical power of attorney.
So when I'm getting ready to pick who I'm going to designate to serve in these roles in my documents, is there anything that I need to keep in mind?
Yes, Sarah, there are several things to keep in mind. So first is that whoever you name in your documents to serve as a financial or a medical decision maker or a guardian, they have to be at least 18 years of age. Preferably, too, they'd be a little bit older and more mature and be able to make those tough decisions, but they have to be at least 18. Secondly, on the medical side of things, it's often beneficial to have someone that's located in close proximity to you. And the reason for that is that if you're hospitalized and that person needs to make decisions, it's beneficial for them to be able to get to the hospital quickly to address those issues. And then on the financial and executor side of things, or trustee roles, we want someone that's competent, right? That can manage their own finances well, that know how to contact the right sources of people to get information. And so, being financially savvy is an important part of those roles.
Okay, Ryan, so you covered all 6 documents a Texas resident should have in place. Do you have any last comments or suggestions about those?
Sure. Just a couple of high-level comments. First, it's really important to have an estate planning attorney help you through this process. An estate planning attorney can help you create a specifically tailored estate plan to your unique needs and circumstances. They can also help you choose financial and medical decision makers, and that's really a difficult choice sometimes. And lastly, the attorney will be around in the event of that emergency to put the plan into action. Separate from that, it's really important to start thinking about if something happens to you, and particularly if you're married to you and your spouse, how is someone going to locate your assets? Right? Who are your key contacts? And so it's really important to start compiling a list of where your bank accounts are located, who your key contacts are, family members, financial advisors, accountants, and also important passwords. Today in life, many of our bank account statements, brokerage statements, and other asset information all comes to us by email. And so at a minimum, we should have our email address and password written down somewhere in a safe place so that if there is an emergency, we can locate the important assets to make sure you're provided for and your family's taken care of.
Absolutely.
And so with that wraps up our Estate Planning 101 on Texas estate planning documents.
Thanks, Ryan.